Hello and welcome back to Immigration News and Views. My name is David Nachman and I'm a managing attorney at Nachman, Verwani, Zemo, Czech Law Group. And with me today again is Felicia Zeidman, one of my colleagues here at the firm. And Felicia and I have some interesting information to bring to your attention. But before I do that, I just want to remind our viewing audience that we have offices in Midtown Manhattan. We also have an affiliated office in India, and we also have an affiliated office in Canada. And Felicia is also licensed in Canada and can meet with clients in Canada and handles Canadian immigration law cases here in the United States. But today, we want to talk to you a little bit about some information that came to our attention recently about the L-1A visa. So, Felicia, why don't you tell our viewing audience a little bit about what's going on?
Well, the L-1A, as perhaps many of the people watching this know, is an intercompany transfer where an executive or a manager or a specialized knowledge worker makes their way to the United States to work in an American branch, subsidiary, affiliate, or otherwise related company in order to perform their specialized position here in the U.S. with having had experience at the overseas branch. So it's a method of creating a valid and ongoing organization here in the United States with workers that know about what's going on at the overseas office. And there are many good reasons to have this kind of visa. Both for the United States government, which is trying to foster the creation of this business here in the United States, and for the overseas company to open up the subsidiary here in the U.S.
Now, and it could be, Felicia, thanks, that's perfect, nice overview for our viewers. And actually one of the things I'd like to point out is that there are two ways in which an L1 can be done. One of them, of course, is that the organization can already be established. So you can have an already established organization, such as any Fortune 100 company, probably very well established, has subsidiaries, affiliates, branch offices abroad, as you rightfully point out. But then there's a permutation, which I've discussed in several other videos that we've done on the L1A classification, and that has to do with what's called a new company L1A. And so whereas with a company that's already established, you get a 3-year grant with increments thereafter, depending upon whether it's L1A or L1B, of up to, if it's L1A, it's up to 7 years. With a new company L, it's a little different. You get an initial grant of 1 year, and then you have to go back for an extension after 1 year, and you have to show that the company is still viable. And now this is, in the past, the L1A has been a fairly routine and straightforward type of visa application to do, and I guess as fairly routine as anything can be in our field, although there are always permutations and nuances to things, which is why we always encourage our viewers to make sure that they enlist the services of a qualified immigration professional. But what is it that's going to be changing in the future now that we've talked to the FDNS officers? What is it that they're going to be looking for?
So initially, the submission would be made to the USCIS, and they would either accept or deny it, and a company would be allowed to transfer their worker. But now there's going to be site visits. At least this is what we're told. And site visits are not strange to us. We've seen site visits for many years in the H-1B context.
Correct, and the R1.
And the R1.
When the site visits were originally brought online, it was for religious organizations, and site visits were actually being done in one of two ways, maybe even in both ways for some organizations. The FDNS officers could actually call up a qualified representative of the organization and have them come for an interview at the district office, which we've seen on some occasions. Or they can actually go out to the site to confirm that it's a bona fide site. And oftentimes they won't give notice that they're going out to the site, but obviously if you're an attorney and you're involved in the case, you would receive notice from the FDNS that they're going out to do the site visit.
Oh, I think that sometimes site visits have happened with incredible speed.
Yeah.
So,
well, sometimes it's a slower process, and sometimes it has happened with speed. That's right. It
so
just depends.
I think that the purpose of this video is to let people know that L-1A site visits are coming down the pipe pretty quickly. And so L-1A applications have to be made with an eye to potential site visits, and the structure of the worker's everyday life should reflect the L-1A application to a great degree. Now, reputable immigration organizations, such as ours, would not be putting together an L-1A application that didn't reflect the everyday life of the worker. However, as anybody who works in an organization knows, things can get out of whack. They can get out of whack for months at a time. And a person who's supposed to be in one position may have to take other responsibilities for various reasons, and may not be where they're supposed to be, and may not always be engaged in what they're supposed to be. And these things now have to be monitored very, very carefully by the petitioning organization.
That's right. And in fact, one of the things that we believe that the government, the FDNS, is inquiring about has to do with geographical locations. Because geographically, a representation is made on the I-129, on the L1 supplement, with regard to where the individual is going to be. Certainly within the L1B context, a representation is made as to whether or not the person is on-site or off-site. In the L1A context, I think we haven't seen it as much, but I think that there is a presumption that the individual is going to be working as a manager executive at the corporate office of the organization. But like Felicia's saying, I mean, for example, let's say you have a large pharmaceutical company and you have an individual who's an L1A who's transferred in as a manager executive, and then what ends up happening is they get transferred, let's say, to one of the other sites. So let's say the corporate office is in the state of New Jersey and they get transferred to a site out in California. So the question is, how do we deal with that type of a scenario in the context of a site visit, and how do we properly prepare our clients to be able to explain that the manager executive is going out to California to handle a particular matter?
Well, I know that if I were counseling a client, the first thing I would say is that those kinds of changes have to be brought to the attention of the lawyer as soon as they are contemplated, so that an application for modification can be made. Some sort of information can be passed on, perhaps to the USCIS, about this change. I would suggest that, certainly.
And that's a great point that you make, and that can happen in one of two ways. The first determination needs to be made as to whether or not there is a material change in the application, and if it is a material change, to the petition, if it is a material change, then of course we know that we would have to make a formal amendment. However, if it's not a material change, then, and obviously the issue of materiality is one that the lawyers have to deal with, if it's not a material change, then of course what we need to do is, and it's probably a good idea, to send a letter to this USCIS. It's possible that it may never get opened, but at least we send the letter to explain to the USCIS what exactly is going on and why. And then, of course, it's probably more so important to get that letter out so that you have a copy of that letter for your file, for your HR file. In the event that there's a site visit, you can open up that file and say, yeah, we notified USCIS that this individual may have to be transferred to the West Coast to take up some particular project.
Yeah, I like that idea a lot. I like the idea of HR having records of attempts to advise the USCIS. Now, David, you were saying there's a second way to handle advice to the USCIS about a change. I'm not sure if we covered that off in what you said here.
Well, I said number one, it was a formal amendment, or number two was just writing a letter, which is not really a formal amendment, but just to notify them as to what's going on.
Okay, so it's good to have those two options, formal and informal. And then I also think it's important for the organization to give some significant consideration to the change they're planning to make. Is it really necessary? It's a big deal, basically. An organization that is used to transferring people here and there and not to having the strictures of immigration visas in place may not realize the importance of maintaining steady parameters around the person that they've petitioned for. But I think the company has to give some very serious thought about whether this particular worker needs to go to the West Coast.
Exactly. And obviously, as these petitions become scrutinized more and more by the government, it's even more important to ensure that you have the appropriate guidance of a qualified immigration professional. So with that, I'd like to thank you very much for tuning in today. We hope this information, of course, is helpful to you or your staff or anyone within your organization. Obviously, this video is about what is to come within the L-1A context. We thank you very much for tuning in, and we look forward to bringing you more developing news in the business immigration arena. Thanks very much.
Bye-bye.
Bye-bye now.